September of last year, so it's almost that. Okay, I'm not gonna wait for that. Yeah, sounds good, so we'll just refuse her and then won't show up. Yeah, okay, sounds good, thank you.
All right, good morning. Okay. All right, looks like the first individual we're gonna see this morning, we have quite a few individuals that we need to see, obviously, for today. The first individual is gonna be Ivanson, Alouidor, followed by Angela Condero. I've gone through many of these cases already, so I'm familiar with the facts, the PC sheets. I'll let you know if there's anyone that I've missed, then I'll need some more information. On this one, I have gone through all the facts of the case as well as the court services notes. All right. So are we ready to proceed?
Yes, Your Honor, the state's prepared.
With Mr. Aloidor, does the court have an appropriate interpreter?
Yeah, we need it's Croatian or Creole.
I believe it's Haitian, Your Honor. Haitian Creole.
I can get one on the language line if we want to just trail this for a minute.
Okay, let's trail it.
All right.
Oh, well then why wasn't he transported?
I think we were continuing it anyhow.
Okay,
But you,
Judge, actually, for that matter, we're gonna seek a 1-day continuance. He wasn't brought down regardless.
Okay. All right, good to know. All right, we'll make a note of that for tomorrow. How about Angela Cordero, excuse me.
Any of you?
Cordero,
All right.
come on up.
We have two for Ms. Cordero. Okay. We ready to proceed?
Yes, Your Honor.
Okay.
Your Honor, regarding the case, the felony burglary of a business, the state is seeking bail in the amount of $20,000 bondable pretrial supervision, testing for drugs and alcohol, and no contact with Boot Barn. Ms. Cordero scores an 8 on the risk assessment, noting pending cases out of this court and Reno Municipal Court. Both cases were at failure to appear status. She also scores 0 points for prior failure to appear. So given those two failure to appears, that would likely raise her score to a 10. The pending case is another drug case, petty larceny and drug paraphernalia. We would ask that that case be set for a review hearing given the new arrest. In the other case, the misdemeanor obstructing and resisting, the state's going to seek $5,000 bondable. Same pretrial supervision with testing for drugs and alcohol, no contact with the co-defendants. There are a number of them. Given Ms. Cordero's multiple failure to appears, we believe she presents a risk of non-appearance. Also, given the fact that in the underlying burglary of a business case, looks like she either did or faked or indicated she had consumed fentanyl while in the backseat of the patrol vehicle in order to be transported to the hospital. So she was not then subsequently arrested and then was now arrested in relation to the big drug bust involving Mr. Perkins and all involved individuals in that case. So given that history, we believe she presents an ongoing risk of further criminal activity, risk of flight, and non-compliance.
All right, so I want to make sure I'm straight on these cases. On the Boot Barn case, you're seeking 20,000, correct?
Yes, Your Honor.
And then on the other case, which is related to the Best Western case on 5851 South Virginia, with the co-defendants, including Mr. Perkins, what was the amount that you were seeking?
$5,000, Your Honor. It is a misdemeanor obstructing.
Right. Okay. All right. Is the, do we have a response?
Yes, so in regard to the resisting case, we're seeking an OR release with appropriate release conditions. I think given the underlying facts and circumstances of that case, just check-ins with pretrial services is appropriate. I don't see any indicia of her engaging in drug use, So I don't think testing at this time is appropriate. Again, that case is a low-level misdemeanor. And the way in which the alleged offense is committed is also fairly mild. It is not deserving nor warranting nor necessitating any type of monetary bail. Now turning to the burglary of a business case, I do think bail is appropriate, but a lesser amount, certainly. I would say $5,000 bondable with a 10% cash option would be fitting under those circumstances. Given that she has an 8 on the MPRA, I think that's what brings us to a point of monetary bail. But the way she scored in that MPRA should be taken into consideration. No prior misdemeanors, no prior felonies, no violence, no failures to appear within the past 24 months, and no multiple substance use arrests. That indicates that she is not a risk to the community, and the points that she is scoring, for the most part, are in that bottom rung, that which shows that she may be a flight risk. Now, turning to whether or not she is a bona fide flight risk, it's hard to say, but she does report to us that she is currently doing side jobs in construction. She is on Medicaid. She is staying locally, and she does have a reason to stick around, just given that local employment, but also this ongoing matter. I do think if afforded that opportunity at a release, she would be successful in supervision, but all the same, for that burglary of a business case, I think a lesser bail is appropriate, $5,000 bondable, again, with that 10% cash option.
All right. So I do believe some bail reduction, given some of the circumstances of the case, would be appropriate, but in the Boot Barn case, her bail is going to be set at $15,000 or 10% cash option. She'll be no contact with 33, looks like 405 Kitski Lane, which is Boot Barn, based on my notes. She'll be subject to pretrial services supervision, and should be tested for controlled substances. On the other case, there'll be no contact with the co-defendants, including Mr. Perkins, also subject to testing, pretrial services supervision. There was a lot of drugs and other items found at Best Western.
Your Honor, I apologize. I didn't catch if you released Ms. Cordero on that obstructing case or if you imposed bail.
I invoke bail.
And was that, what was that amount on the obstructing case?
3,000.
10,000.
Thank you.
All right. Looks like the next person is Kenny Case, followed by Byron Bent.
Did he waive?
This is also,
Yes.
this is also the Best Western case as well, so.
All right, for Mr. Bent, we're just seeking to waive his appearance and we'll proceed with the Mr. Case. Okay, with Mr. Case, we spoke with him earlier today. We're prepared to proceed in waiving his appearance.
All right. State ready to proceed?
Yes, Your Honor. In this case, the state is going to seek bail in the amount of $5,000 bondable, pretrial supervision with testing for drugs and alcohol, and no contact with the co-defendants. Mr. Case scores a 9 on the risk assessment, noting a pending cases out of the Reno Municipal Court at failure to appear status. His criminal history is somewhat distant. He had a 2019 arrest for failing to appear, a 2018 felony conviction for driver disobey a police officer while driving under the influence. He also had a felony arrest for possession of stolen property, which was deferred. Those are both out of Carson. That same year, he had a gross misdemeanor conviction for conspiracy to commit burglary out of Carson City. And then in 2014, he had a misdemeanor drugs not for interstate commerce conviction. So given that history, Your Honor, the facts of this case, we do believe bail is appropriate and the least restrictive means.
All right, do we have a response?
Yes, at this time, we're seeking an OR release with appropriate release conditions. Given the facts and circumstances of this case and the way in which Mr. Case scored on the MPRA, I do think the only real supervision conditions to be imposed are no contact with the co-defendants, and regular check-ins with pretrial services. Again, this is a common resisting case. It's a low-level misdemeanor. There is no victim. There is no allegation connected to Mr. Case specifically about theft, about violence, about possessing weapons, about drug use himself. This is just a matter of not obeying a command. I think that alone does not warrant nor necessitate any amount of bail, especially if his MPRA score is not astronomical. In this case, it is a 9, but all the same, in that 9, there's no points for prior violence, no points with recent failures to appear, and no multiple substance use arrests. So I do think he would be supervisable on pretrial release for this type of offense.
But he does have a felony in the past 10 years. Just like the last case, some bail is appropriate. It's going to be $3,000. No contact with the Best Western, which is 5851 South Virginia. No contact with the co-defendants. Subject to testing, in this case because of the felony, shall not possess firearms or weapons. And then he'll be subject to pretrial services supervision. All right. Some bail is appropriate given the amount of drugs and weapons that they found at this place. All right. Next individual is going to be, looks like Laron Bent, followed by Mr. Katz. Then followed by Jacob Massey. All right. State ready to proceed?
Yes, Your Honor. In this case, the state is going to seek bail in the amount of $10,000 bondable, pretrial supervision. I didn't see any indication of drug or alcohol use in this case, which would provide a nexus for testing. So those would be the sole conditions. Your Honor, Mr. Bent scores an 11 on the risk assessment, noting a point for prior failure to appear, 2 points for prior violent crime convictions, and that he was only in the city of Reno for 2 days when he committed this crime. His history is all out of the state of California, including an arrest from this year for a felony cause or permit injury to an elder, as well as a probation violation. He also had a battery arrest from this year out of California with no disposition and a petty theft arrest with no disposition. Last year, he had a felony arrest for robbery with no disposition. Then in 2023, he had 2 felony convictions in separate cases, one for a post-release community supervision violation and the other for a robbery in the 2nd degree. He had a failure to appear felony arrest in 2022. And then in 2021, excuse me, he had felony convictions for assault with a deadly weapon with force, resulting in possible great bodily injury. A second felony conviction for assault with a deadly weapon, not a firearm, as well as a felony conviction for assault with a deadly weapon with use of force and misdemeanor obstructing. He also had a felony arrest for a sex with a minor and misdemeanor indecent exposure that showed no disposition and a misdemeanor battery. He does have other history going back as far as 2017, but those are the highlights. So given that history, Your Honor, his lack of ties to this community and the facts of this case, we do believe bail is appropriate.
All right, do we have a response?
Yes, at this time, we're seeking lesser bail in the amount of $3,000 bondable with a 10% cash option. Given Mr. Bent's criminal history, some amount of monetary bail is warranted, especially in light of his lack of ties to the community. But when considering the factual allegations of this case and the level of charge that Mr. Bent is facing at this time, a lesser amount of bail is more appropriate and more fitting, just given the circumstances. Right now, the highest charge he's faced with is a gross misdemeanor. There is no felony in sight, so that should be taken into consideration. In addition to that, the way in which the offense was committed or allegedly committed, it didn't involve direct person-to-person contact, so there is no specific victim in this matter. Again, I don't think 10,000 bondable is appropriate with these facts, but all the same, we're seeking that $3,000 bondable with a 10% cash option.
I would be inclined to agree with you, but for He's failed to appear in his risk assessment of 11 with prior violent crime convictions and felonies and FTAs. So I'm gonna set his bail at $7,500. 10% cash option, obviously. Shall not possess firearms or weapons. Pretrial services, pretrial services supervision. All right. Next individual is Mr. Katz, Lee Katz.
Yes, for Mr. Katz, we weren't able to speak with him today, given his medical situation at the jail. So we're gonna ask that this be continued just one day.
All right. So have you had a chance to speak with him?
We attempted to, but again, given his medical situation, he was unable to actually have contact with us.
All right, fair enough. You might want to discuss, he marked he's going to retain private counsel. So you might want to ask him how he wants to proceed. All right.
All right.
Okay, next is, looks like, let me see, Mr. Williams.
I believe you indicated Mr. Massey would be after.
Oh, I'm sorry, Mr. Massey. Then Mr. Williams.
All right, with Mr. Massey, we spoke with him. He is currently sick. We would ask to waive his appearance and proceed with the bail hearing.
All right. Okay, is the state ready to proceed? It's a battery and a protected person. Looks like it occurred at St. Mary's.
Yes, Your Honor. So in this case, the state is going to seek bail in the amount of $5,000 bondable pretrial supervision. Mr. Massey scores a 10 on the risk assessment. He does have significant misdemeanor criminal history, including some prior felony crimes of violence. Most recently, he was convicted in 2025 of misdemeanor trespassing out of the Reno Municipal Court. He had another trespassing conviction in 2024, as well as a disturbing the peace out of this court. In 2020, he had a felony conviction for domestic battery third offense locally. And in that PSI, it indicated he had 48 prior misdemeanor convictions and 0 prior felonies. A number of those prior convictions are batteries, domestic batteries, and other like crimes of violence. So given that history, Your Honor, we do believe some monetary bail is appropriate in this case.
All right, do we have a response?
Yes, we would ask monetary bail be set in the amount of $2,500 bondable with a 10% cash option. I do see the state's point in establishing that monetary bail is required or necessitated given the background of Mr. Massey. But given the factual allegations, they're fairly insignificant in terms of depth of injury and alleged harm. It appears to be one strike, no apparent injury thereafter, no long-lasting pain, no medical intervention required for the alleged victim. I think that should be taken into consideration for the bail amount, and that is why our request is $2,500 bondable with a 10% cash option.
Then I just wanted to confirm with the state. I didn't appear on his risk assessment, but I believe you'd mentioned there's some substance abuse in Mr. background.
You know, Your Honor, I didn't see any in his recent background or in the risk assessment, and I don't believe it was sufficiently noted in the probable cause sheet, so I was not requesting testing.
All right, let me just check something else here.
It looks like his most recent alcohol-involved offense was out of the Reno Municipal Court in 2016 with a couple open containers.
I'm going to set his bail at $5,000 or 10% cash, no contact with St. Mary's, and the named victim, Harley Tuttle, shall not possess firearms or weapons, pretrial services supervision. All right. All right. What was that? All right, so we get to this next case. All right. Now we can see, looks like Kenyon Williams.
Yes, we spoke with Mr. Williams today. We're asking to waive his appearance and proceed with the bail hearing.
All right. So it looks like we've got preventing or dissuading a witness as well as larceny. Is the state ready to proceed?
Yes, Your Honor. In this case, I would just note for the court that it was charged as the preventing, dissuading category D and petty larceny. However, given the facts of this case, the state will likely file the petty larceny as a larceny from person under 205-270, a category C felony, as the phone was taken from the victim's hand. And Mr. Williams scores the highest risk score possible on the risk assessment at a 17. So given that, Your Honor, the state is going to seek bail in the amount of $40,000 bondable, pretrial supervision, testing for drugs and alcohol, given his recent history, including in this court, and no contact with the named victim or Griffles Biomat at 270 East 6th Street. His history includes two trespassing arrests this year, a trespassing conviction out of the Reno Municipal Court, and a separate case for battery conviction out of the Reno Municipal Court. Last year, he did have multiple similar convictions, as noted, including failure to appears. He also was convicted of possession of a controlled substance where he received diversion. His diversion was then subsequently revoked. In 2014, he again had a misdemeanor conviction for failing to appear, trespassing, obstructing and resisting, batteries, including out of this court. And then felony or gross misdemeanor history, he has a 2022 felony conviction for pandering, where probation was temporarily revoked and he was then subsequently dishonorably discharged. He had a battery with a deadly weapon arrest where no charges were filed. He had a 2018 gross misdemeanor conviction for attempted carrying a concealed weapon. Again, in that case, his probation was revoked and expired his sentence in 2016. Another attempt, battery with substantial bodily harm in this case. Again, probation revoked and voluntarily withdrew from specialty court. So given that history, Honor, the high risk score, facts of this case, we do believe bail to be the least restrictive means. And we would also ask for no weapons, given the facts of this case.
Yeah, correct. I would agree with that. So we have a response?
Yes, so at this time, we're seeking a lesser amount of bail. Yes, Mr. Williams scored a 17 on the MPRA, and given his additional information that he provided us, it appears that he doesn't set himself up for success when he is given the opportunity at pretrial release. I do believe bail is warranted and necessitated given his background and the facts and circumstances. But I think it should take into consideration that these allegations are not terribly severe, right? It's potentially a category C felony with a category D felony. It's not a B or an A. There is no violence. There is no use of a weapon during this alleged incident. So I think that should be factored in for his bail amount. And in speaking with Mr. Williams, I've represented him previously on that deferral matter for the possession of a controlled substance case. I know Mr. Williams struggles with mental health issues and substance use issues, so it's a co-occurring issue with Mr. Williams, and ultimately he needs long-term stabilized treatment. I think one way we get to that point is a modest amount in bail that keeps him in custody until we can figure out an action plan going forward. I think 40,000 is too steep given the allegations. I do think something more appropriate would be 20,000 bondable with a 10% cash option.
And then to confirm, the state did request 40,000, correct?
That's correct, Your Honor.
All right. And you said that he's only going to be charged with the larceny, correct?
Your Honor, given the facts of this case, it's not going to be my charging decision, but I did indicate after my review of the case that I did believe that to be the appropriate charge. So while I can't say for sure that that will be, I do believe that it qualifies and will likely be charged.
All right, I'm gonna set his bail at $25,000. No contact with Griffon's Biomat, which is 270 East Sixth Street. Subject to testing, shall not possess firearms or weapons, and he'll be subject to pretrial supervision. All right. All right. Let me get out of this case. Next is going to be Jessica, I believe it's Burge, or maybe Berg,
Bergie?
followed by Adam Renner. All right. State ready to proceed?
Yes, Your Honor. In this case, the state is going to be seeking bail in the amount of $150,000 bondable pretrial supervision with testing for drugs and alcohol. No contact with Christopher Cook.
Right.
Miss Berge does score lower on the risk assessment at a 5 and has limited criminal history. She was arrested in 2017 for domestic battery first offense. That case was then dismissed. And in 2012, she did have a gross misdemeanor conviction for attempted possession, obtain or possess credit or debit card without consent. So limited criminal history, Your Honor, but given the facts of this case and the large amount of narcotics, as well as the likelihood of conviction, given that the narcotics were found in Ms. Berge's bags within the vehicle, we do believe that some monetary bail is appropriate. This does present a fairly significant risk to the community selling these types of narcotics. So we do believe bail and supervision with testing to be appropriate in this case.
All right, do we have a response?
Yes, we're seeking a lesser amount in bail, and the amount of 10,000 bondable. While she scored outright with a 5 on the MPRA, that initial score showed no prior misdemeanors, no prior felonies, no prior violence, no failures to appear, and no multiple substance use arrests. So not truly a risk to the community, nor much of a flight risk. In addition to that, we were able to verify that she has a local place to stay, she has a job, and she has a verifiable phone number. That would knock her MPRA score from a 5 to a 1. So a very low risk to reoffend and a very low risk to be a flight risk on pretrial release. I think that absolutely needs to be taken into consideration when determining what amount of bail is set in her case. Now, while the allegations are quite severe, I think the state kind of touched on it a little bit in the sense of, well, she has very light criminal history and there was another individual involved in this situation. There is a strong likelihood that this is not actually connected to Ms. Berge, but instead is what she purported at the scene. I think that needs to be factored in for her bail amount. I do think with everything considered, with the MPRA score being knocked down to a 1, with her being likely very supervisable if afforded that opportunity, and with the intervening existence of another individual who seems to be much more likely to be that top dog in terms of whose drugs these are and who's really owning this operation, I think 10,000 bondable for Ms. Berge is appropriate at this time.
We're talking about a trafficking count, 113 grams of meth.
It's actually 171 grams of meth in total, Your Honor.
Yeah, I'm sorry about that. I was just going off of my notes here. It was total weight was 171.3. All right, not to mention the digital scale and the glass pipe. So I'm going to set her bail at $100,000. All right, no contact with the co-defendant Chris Cook. Should be subject to testing. Shall not possess firearms or weapons. All right, it should be subject to pretrial supervision.
I apologize, Your Honor. Will the supervision include testing?
Yes.
Thank you, Your Honor.
F testing. Shall not possess firearms or weapons, pretrial service to supervision. And then since it looks like the public defender verified her information, she would have to reside at 6600 Rolling Meadow Drive, Unit 2913. No contact with the named co-defendant, Chris Cook.
And Your Honor, just for the sake of the record, Mr. Cook was not charged in relation to the trafficking. In this case, he does have separate charges at the time of the arrest. So he is not listed as a co-defendant in this case specifically, but he did pick up charges during the same arrest and contact.
Oh, I thought you indicated no contact with the
Just that they had shared a vehicle. So while he is
Right.
not a listed co-defendant, I just wanted to make the record clear, he is not a co-defendant in the case, but I am still seeking a no contact order as they were found together in the vehicle, or they
All right.
arrived at the scene in the vehicle together.
Right, you're correct. So no contact with Mr. Cook. All right.
15,000.
Let's see. Next is Adam Brenner, followed by actually Mr. Chris Cook. We have two for Mr. Cook. All right, is the state ready to proceed?
Your Honor, we have been unable to contact the victim in this case as it is listed as pandering constituting domestic violence. I would request 24 hours for Marcy's Law.
All right. All right, so we'll bring back Mr. Brenner.
They'll be having their bail hearing tomorrow. They need to try to reach the other individual first.
All right. Next is Mr. Cook.
Spoke with Mr. Cook today. We would ask to waive his appearance and proceed with the bail hearing.
All right. Looks like we have two for Mr. Cook. Just get those in order. Okay. Is the state ready to proceed with Mr. Cook?
Yes, Your Honor. So a point of note, while Mr. Cook is facing two separate cases with these charges right now, given the facts of the case and the timing of the arrest, the state will likely combine the two as they do involve similar conduct and a similar means of criminal activity. So my argument would be that bail be imposed in the amount of $60,000 bondable on each case. And when combined, that total for $120,000 bondable. Mr. Cook scores a 7 on the risk assessment, noting 2 points for substance abuse related arrests. However, the basis for the high bail in this case, given the lower level felonies at category Ds, is that Mr. Cook is eligible for habitual criminal enhancement. In 2024, he had a felony arrest for a probation violation. In 2022, he had 2 felony failure to appear arrests, as well as a possession of stolen property conviction locally as a felony, and that's in CR 19-1455. The PSI in that case lists 17 prior felony convictions, 1 misdemeanor and 6 misdemeanors. Looking at only failure to appears or felony convictions in 2020, he had a failure to appear, a felony theft, and a felony burglary. Most of these felonies are out of California, with a few being locally. In 2017, he had a felon or addict in possession of a firearm, possession of a stolen motor vehicle. 2014, he had a felony receiving known stolen property that was then subsequently reduced to a misdemeanor, but he also that year had a felony taking a vehicle without consent. In 2013, taking a vehicle without consent, as well as a possession of a controlled substance, and then in a separate case, 2 counts of burglary. A 2011 use or get credit card or ID of another, as well as a felony petty theft with prior, and then another get credit or use others' ID. And then in 2010, possession of a controlled substance, 2008, evading peace officer, and a felony possession of a driver's license with intent to commit forgery, and a 2006 felony burglary and felony conviction for receiving known stolen property. So, Your Honor, highlighting those specifically later mentioned possession of stolen property and burglary cases, as well as his use or ID of credit of another, similar conduct in this case, while flipping owned trailers, not necessarily a crime of violence. The impact on the community is significant. This was done multiple times. As given that criminal history, Your Honor, we will likely pursue habitual criminal enhancement. So we do believe that a higher bail is appropriate. We'd ask that he have no contact with the 2 named victim businesses, IGC Construction and I think it's Nevada Roofing Division, as well as the named victims in the case to whom the trailers were sold. So that would be my request, Your Honor.
How much is he asking for on each case?
60,000 on each case.
Thank you, Your Honor. That's true.
All right, do we have a response?
Yes, we're seeking lesser bail in the amount of, well, in total, $50,000 bondable, no 10% cash option. I guess that would split 25 to 25 between the 2 cases. And speaking with Mr. Cook, he doesn't have any means to post any amount of bail. So what the court strives to achieve through the bail order can be achieved with $100 bail if you really wanted to. I think $120,000 bail across the 2 cases is excessive at this point in time. Yes, Mr. Cook has lengthy criminal history, and it is severe criminal history at that. But when you take the facts of this case into consideration, it is only theft. There is no additional violence. There's no weapon use either. With that, the depth of theft is probably commonly in the category C range of theft charges. So not that higher end category B felony type theft we see on a semi-regular occasion. With that, he also scored a 7 on the MPRA for no recent violence, no recent failures to appear, with a verified residence and a verified phone. I think all of that needs to be factored in when considering his bail amount. And I do think the ultimate reasonable outcome is $50,000 bondable across the 2 cases. So $25,000 on the first case and $25,000 on the second.
His bail is going to be set at 50,000 on each case. There'll be no contact with IGC Construction and Nevada Roofing, and the victims, McDade and Eric Perez, subject to testing and pretrial services and supervision.
And Your Honor, my apologies. I did forget to request a reciprocal no contact order with Miss Berge.
Correct. Actually, I have her down. Okay, so again, no contact, subject to testing, pretrial services, supervision, and the amount will be 50,000 on each case. Okay. All right, looks like the next individual is going to be Eric Helderman. Excuse me, Kirk Helderman.
I spoke with Mr. Helderman today. We would ask to waive his appearance and proceed with the bail hearing.
All right. Is the state ready to proceed?
Yes, Your Honor, in one moment, if I may.
Yeah, it's a possession case.
Yes, Your Honor. So the state is going to seek $10,000 bondable for Mr. Helderman in this case. He again was part of the Best Western,
Right.
for lack of a better term, takedown of the drug operation. He was contacted by law enforcement, and he did have a little more involvement than the others we have seen today. He was found with that backpack in which guns, drugs, and money were found. He also had the controlled substances, namely 1.35 grams gross weight fentanyl in his person, as well as $173 in cash. He scores higher on the risk assessment than the others we've seen today at an 11. And he does have some fairly significant criminal history, including a trespassing conviction from last year and a failure to appear. In 2023, he had a possession of a controlled substance case, which was deferred, a 2022 felony conviction for vehicle burglary. He was removed from specialty court in that case. And then in 2017, a felony conviction for assault with a deadly weapon. He did have several probation violations in that case. That was out of California. 2008, a DUI with a failure to appear out of California, and a 2004 wet reckless. So given the conduct, failure to appears in history, especially felony history, we do believe that a little higher bail is appropriate than the others we've seen today at $10,000 bondable. We'd also ask that he have pretrial supervision, testing for drugs and alcohol, and no contact with any of the named co-defendants.
All right, do we have a response?
Yes, at this time, we're going to submit on the requested monetary bail amount, but we would ask that there be an alternative permitted, where if we get a qualifying substance use evaluation on the record, that Mr. Helderman be able to be directly transported through IAP to a residential treatment or inpatient facility. Given the charge he's facing and his criminal history and the surrounding events of this exact arrest, it's clear that Mr. Helderman had a very low involvement in this case. It's just that he works for drug payment in return. He clearly has a drug use issue, and the only way to solve that is through treatment. It's not going to be solved through incarceration, and it's not going to be changed over the next couple of months merely because he is drying out. I think in the interim, we should start working towards a way to build up Mr. Helderman, and we can do that through structured transport to inpatient.
All right, does the state have a response with respect to the direct transport?
I would just note that he had the opportunity of specialty court in 2022 and was removed and then was sent to prison. However, the following year in 2023, he did have that possession of a controlled substance case, which was deferred. I would note he has had multiple chances to get sober and remain sober, and then now is wrapped up in this conduct. So we would object.
Thus he scores 11. All right, so his bail is going to be set at $10,000, no contact with the co-defendants, including Best Western 5851 South Virginia. He's subject to testing, shall not possess firearms or weapons, and he'll be subject to pretrial supervision. All right, looks like it's John Stevens who's next,
Judge, I would ask to trail Mr. Stevens' case.
right? Okay. So we'll trail Mr. Stevens. Next is Mario, looks like Vale. All right, is the state ready to proceed?
Yes, Your Honor. So this is an interesting case. I would ask before I make any argument if the court has any information on the pending case, RCR 2026-133980. The issue on this case is that Mr. Valle was arrested on that PC in the case I just mentioned, and law enforcement basically developed probable cause at that time for these same charges. He then, I was unable to determine if he was OR'd on that case or posted bail. But then law enforcement then saw him later without any further criminal conduct and arrested him on that same PC from the same night they arrested him on the original PC. So, Your Honor, I think it would be out of turn for the state to request any revocation on the underlying case. I don't see any new criminal conduct. I did note that they filed a pretrial violation report given the new arrest, but as the conduct was all committed on the same date, I think that bail on this case, given the charges and the provability, is appropriate. I just am not sure what happened on that underlying case, if I could.
Yeah, the clerk's looking.
So. So he is not in custody on that case. It just says that he was arrested on new felony charges.
So, Your Honor, we're not going to be requesting a review hearing on that case, but given the facts of this case, we do believe bail is appropriate. We'd ask for bail in the amount of $10,000 bondable here. Again, that is due to the provability.
Sorry to interrupt you. That case is set for a preliminary hearing. He hasn't even been sentenced on that case.
Oh, I'm aware.
Okay.
No, I'm aware. I just saw that he was picked up on those charges. I didn't see that he had a bail hearing in our notes, so I assumed he was released prior to a bail hearing or posted bail.
He never had a bail hearing. He was OR'd.
Okay, so given that, Your Honor, we're not going to request a review hearing. We would ask that this case be set at what date is the preliminary hearing on that case?
3/23.
Okay. So we are not going to ask that it be set at the same time as that, given the facts. They are different than the underlying probable cause in that case, but we do believe bail is appropriate in this case. $10,000 bondable, no firearms, testing for drugs and alcohol with pretrial supervision. He scores a 9 on the risk assessment. He does have that pending case before the court, but as noted, this is not new criminal conduct. Prior to that, he had a misdemeanor conviction for harassment out of this court, a 2011 misdemeanor conviction for minor in consumption, and other alcohol-related arrests as a minor before that. But given the provability, Your Honor, this I do believe bail is appropriate in this case.
All right, we have a response.
Yes, at this time, we're seeking an OR release with appropriate release conditions. I think random drug testing is appropriate given the factual allegations along with a no weapons clause. While Mr. Valle scored a 9 on the MPRA, there were no points for prior felonies, prior violence, prior FTAs, and prior multiple substance use arrests. In addition to that, we were able to verify that he has a job, that he's currently working, that he likely does have a place to stay if he is released, and that he has a personal phone. That would bring down his score from a 9 to a 5. That's a low moderate. And I think that is kind of replicated into why Judge Pearson made the decision to OR on the Pratt in his prior case, in that it scores ultimately such a lower score that it reflects that I think under Valdez-Jimenez, his release is mandated, is appropriate. It is the only constitutional outcome for this case. Again, I think with appropriate release conditions, we can mitigate much of this criminal conduct that Mr. Valle finds himself involved with. So I'm seeking that opportunity for him at this time.
All right, so let me just check one other thing in my notes here. So you were able to verify his address? Because court services was not able to.
He provided us an address of 1336 Butler Street, and that will be with his father.
Right. That's what was indicated in the PC sheet. All right, I'm gonna set his bail at $5,000. He'll be subject to testing. Shall not possess firearms or weapons. He must reside at 1336 Butler Street, and he'll be subject to pretrial supervision.
I'll set up with that.
All right. Next is Dante Washington. Okay, stay ready to proceed.
Yes, Your Honor, we're going to seek bail in the amount of $10,000 bondable, pretrial supervision as the sole condition. The facts of this case are that he was communicating with an undercover officer posing as a renegade prostitute, where he then encouraged and attempted to gain some of the proceeds of her work through their conversations over the course of approximately a week and a half. Scores a 6 on the risk assessment, noting that all of his criminal history is out of California and is fairly limited and distant. In 2011, he had 2 misdemeanor convictions for robbery, as well as 2 misdemeanor convictions for assault with a deadly weapon, and noted juvenile history prior to that. But given the facts of this case, Your Honor, and his admissions to law enforcement, we do believe that some monetary bail in this case is appropriate.
Okay. We have a response.
Yes, at this time, we're seeking an OR release, appropriate release conditions. I think given the allegations, a no weapons clause is appropriate. And since it was a sting operation, there really isn't no purpose for a no contact order. While Mr. Washington scored a 6 on the MPRA, there were no prior misdemeanors, no prior felonies, no violence, no failures to appear, and no multiple substance use arrests. He does have some criminal history, but it's over, I think when I checked, like a decade and a half. So he has seemingly left that life behind him, save it be these allegations. Now turning towards the allegations, it struck me more so as though he was trying to just impress some girl in a very stupid way. Ultimately, it backfired. Hopefully he can learn from that, but at the same time, I don't think monetary bail is necessitated given these allegations, given the way in which Mr. Washington allegedly committed the offenses. In addition to that, and speaking with Mr. Washington, he reports that he has stable work with a security company. He does report that he has an address he can return to if released, and he reports that he does have a phone number. So he would be living locally, he would be readily contactable, he would be able to go to court and maintain his pretrial release conditions if afforded that opportunity.
Yeah, we were able to verify that, independently verify his address.
We tried to reach out to an individual who could verify, but ultimately he was unable to connect back with us to give us a response.
All right. I'm willing to reduce his bail to 5,000, but I have to have his address verified, so I know he has a place to live. So that'll be a condition. If we're able to satisfy that condition, then and he posts, then he will be released, subject to shall not possess firearms or weapons. Again, he must reside at 426 12th Avenue, Unit A, and he'll be subject to pretrial services. All right.
Yep.
Next is Raul Avina. Followed by Lorena Cortez Sandoval.
No,
All right. This is another Best Western case. Is the state ready to proceed?
Yes, Your Honor. In this case, the state is going to seek $5,000 bondable pretrial supervision with testing and no contact with the co-defendants. As noted, this was another individual involved who failed to exit the room upon SWAT commands. He scores a 7 on the risk assessment. Earlier this year, he was convicted of drug paraphernalia out of this court. Last year, he had a drug paraphernalia and petty larceny arrest that was pending at the time. He did have a failure to appear in that case. 2023, he had misdemeanor convictions for resisting and drug paraphernalia, a failure to appear arrest, a gross misdemeanor attempted possession of a stolen motor vehicle. It looks like he ended up in that case receiving a 180-day jail sentence because in Department 1, they found him to be unsupervisable after numerous pretrial violations and numerous pretrial failure to appears. The PSI in that case lists 19 prior misdemeanor convictions and 9 failure to appear warrants. So given that history, Your Honor, we do believe there's a risk of non-appearance, risk of non-compliance, and bail to be the least restrictive means.
All right, do we have a response?
Yes, at this time, we're seeking to know our release for Mr. Avina with appropriate release conditions. I think just checking in with pretrial services should do enough. Again, the charge, low-level misdemeanor, fairly inoffensive in the way in which Mr. Avina is allegedly committing said charge. It's just failure to obey an order. The PC sheet itself is basically replicated across several co-defendants. I think that tells me that there was nothing unique about Mr. Avina offending. And I think that should be factored into whether or not he can be safely supervised in the community, awaiting a final determination in his case. He scored a 7 on that MPRA, but no points for prior violence or recent failures to appear. He also had a verified residence and a verified phone. We were also able to verify some form of work for Mr. Avina. So that would mark his score down from a 7 to a 6. I think as a low moderate or a mid moderate on a low level misdemeanor, single charge of resisting arrest in which there is no victim, I think the only appropriate outcome is an OR release with appropriate release conditions.
Yeah, other than the fact that he has substantial failure to appears and failure to comply, looked like he had multiple FTA warrants. So his bail is going to be set at $5,000 or 10% cash option. No contact with 5851 South Virginia, Best Western, and the other named co-defendants. He'll be subject to testing, not possess firearms or weapons. It looks like they were able to verify his information, so he must reside at 3040 Santa Ana Drive, and he'll be subject to pretrial supervision.
Your Honor, will that include testing?
I have testing, yes. So like all the rest of, like all the other similar cases. All right. Looks like we have Lorena Cortez.
She didn't have a PDF.
All right, so just give me a minute, Ms. Cortez. Did you have an opportunity to interview with pretrial services concerning an appointment of a public defender?
Huh? No.
Okay, answer.
Yes.
All right, so I need you to raise your right hand, and I'm gonna have to ask you some financial questions. Do you swear to tell the truth, the whole truth, nothing but the truth under penalty of perjury? I need a yes from you, please.
Yes, Your Honor.
All right, are you still employed full-time with Johnny's Auto Body Shop?
Yes, Your Honor.
And you're a receptionist?
Yes.
All right. And what is your gross weekly income?
I get paid 16 an hour. I get bi-weekly.
And it's bi-weekly?
Yeah.
All right, and You live at 1655 Hillborough Avenue,
Yes, I do.
and do you support anybody else besides yourself?
My daughter. Well, my oldest daughter and my two other daughters.
And do they live with you?
My oldest one does, and my two other ones they don't.
All right. Well, I'm going to appoint a public defender to represent you in this case. All
Okay.
right. All right, is the state ready to proceed?
Yes, Your Honor. Again, Ms. Cortez Sandoval was one of the individuals caught up in the Best Western sting.
Right.
She again is noted to have failed to exit the room upon commands. I would note the only other point specific to Ms. Cortez Sandoval is law enforcement did indicate she appeared to be under the influence of narcotics when they
Right.
contacted her, as she was on the nod. So, Your Honor, given that, my request will be similar to the other co-defendants, $5,000 bondable pretrial supervision with testing and no contact with the other co-defendants. She scores a 7 on the risk assessment. This year, she was previously arrested for violating conditions of a suspended sentence. She had a misdemeanor battery conviction out of the Reno Municipal Court last year, a misdemeanor destruction of property out of Sparks Justice in 2017, misdemeanor petty larceny in 2016 and 2015, a drug paraphernalia conviction in 2014, and a misdemeanor domestic battery first conviction in 2012. So, Your Honor, given the facts of this case, we do believe that bail is appropriate.
All right, do we have a response?
Yes, at this time, we're seeking an OR release for Ms. Cortez Sandoval with appropriate release conditions. I think, again, pretrial supervision is probably appropriate. I have no doubt in my mind that she would be able to comply with that. In the MPRA, scored a 7, no prior felonies, no failures to appear, no multiple substance use arrests, and a verified phone. She's not really a risk to the community. Much of what the state read off as her criminal history is quite stale. I mean, 2016, 2015, 2014, that's quite different from how Ms. Cortez Sandoval presents now, albeit she did have that more recent singular misdemeanor conviction. I think that should be taken into consideration. When she is committing offenses, they are low-level charges. They are never the gross misdemeanors, the felonies. It's nothing significant. Again, we also reached out to a contact on her behalf, able to verify that she had employment, has a place to live locally. In addition to that, she has a phone, right? So marks her score from a 7 to a 4. She's a low risk to offend on a low-level misdemeanor. Truly, it's necessitating an OR release with appropriate release conditions. There is no basis to order monetary bail for Ms. Cortez Sandoval at this time, certainly not carried by the burden of proof that the state has to hold for clear and convincing evidence in that regard. So with that, we will submit with our OR request.
Yeah, but she was overridden to a high risk because she had that active suspended in a municipal court sentence. Looks like she was released on February 1st. And then shortly reoffended. Also indicates that she has a history of nuisance arrests and failing to handle court matters. So I'm going to set her bail at $3,000 or 10% cash. No contact with 5851 South Virginia Best Western. No contact with the co-defendants in that case. Subject to testing. Must reside at 1655 Hillborough, and pretrial services supervision.
All right, you're good.
All right, next is Francisco. Last name Heredia, followed by David Nez. What?
We have to switch over?
So we want
Okay.
to put them.
Yeah, where's your blank ones?
The books out.
Okay, okay,
These are the ones that I filled out. Didn't have time to fill out
okay.
the ones.
okay.
Okay. Is the state ready to proceed?
Yes, Your Honor. In this case, we're not going to object to Mr. Heredia's release on his own recognizance. We'd ask that the sole conditions be pretrial supervision and no possession of firearms or weapons. He does have a prior felony conviction for duty to stop at the scene of the accident with injury in 2021. But outside of that, he does have a recent misdemeanor battery from last year. Outside of that, his history is, again, rather stale. So we believe that release is the least restrictive option, and with those noted conditions to be the best way to move forward.
Then, looks like they did verify his information. Do you still live at 1422 East 9th Street, Unit 8, sir?
Yes.
All right. All right, so you'll be released. In this case, shall not possess firearms or weapons. You must reside at 1422 East 9th Street, Unit 8, and you'll be subject to pretrial supervision. All right. All right, next is David Nez.
His arraignment will be March 25th.
All right,
For out of custody arraignment.
yeah.
And then court services on the right.
I spoke with Mr. Nez. I would ask to waive his appearance and proceed with the bail hearing.
All right. So we have a possession of a stolen motor vehicle, possession of drug paraphernalia, and then possession of fentanyl. Is the state ready to proceed?
Yes, Your Honor. Regarding the possession of stolen motor vehicle, we're going to seek bail in the amount of $20,000 bondable, pretrial supervision, testing for drugs and alcohol, and no contact with.
Carlos?
Yes, I was going to try to find the address of the apartment complex, but no contact with the named victim. Mr. Nez scores a 14 on the risk assessment, noting 2 points for prior failure to appear. He did have a bench warrant out of the Reno Municipal Court cases, out of the Reno Municipal Court. Reno Muni notes 25 drug paraphernalia, for a 2025 drug paraphernalia case. Looks like this year he has the pending possession of a controlled substance case that will likely combine here. So, Your Honor, we'd ask for this to be one total bail. Last year, he was arrested on carrying a concealed weapon and drug paraphernalia. He had a failure to appear in that case and then had a $1,000 cash-only bench warrant issued. Looks like he was then subsequently OR'd due to the filing of misdemeanor charges on that. In 2000, he also had a drug paraphernalia citation last year with a failure to appear bench warrant, another drug paraphernalia conviction and trespassing conviction. Then in 2024, another drug paraphernalia conviction out of this court, as well as a destruction of property out of this court, multiple failure to appears, and order to show causes. And similar history going back. I don't know any prior felony history. However, he did have a 2013 contempt of court arrest. So, Your Honor, given that history of non-compliance and failure to appear, we do believe bail to be appropriate in this case, and least restrictive means pretrial supervision to be appropriate given the narcotics and the no contact order.
What about his other case? What did you ask for on that case?
Yeah, that's going to be my play. I thought you said you wanted 20,000, you wanted them combined, so 20,000 for both?
Yes, Your Honor. We will likely combine the two cases.
All right, so 10,000 on each then?
I'd ask that it be split 15 on this case and 5,000 on the PCS.
All right. All right. Are we ready to proceed?
Yes. In terms of our request right now, I think bail is necessitated, given Mr. Nez's prior MPRA scoring and the criminal history and the outstanding warrants. It's clear that he's not supervisable necessarily, but all the same, the bail amount as requested is excessive. There's nothing particularly harmful in this set of factual allegations for this type of charge. We get this type of charge all the time. Nothing was particularly notable for this. And so I don't see a basis to make it such a high bail. As a result, I would seek bail total amount to be 10,000 bondable with a 10% cash option. And I would ask that split be 8,000 bondable with a 10% cash option on the stolen motor vehicle case and 2,000 bondable with a 10% cash option on the possession case.
All right. So on the possession of stolen motor vehicle case, his bail is going to be set at $15,000, 10% cash option, no contact with Carlos Cortez, Southwest Village Apartments, subject to testing, shall not possess firearms or weapons based on his background, pretrial services supervision. On the other case, I am going to set his bail at $2,000, subject to testing again, shall not possess firearms or weapons and pretrial services supervision. Okay. Next is Jennifer Parasso. All right. Okay, ready to proceed with Ms. Parasso.
Yes, Your Honor. If I might just have one moment, please, while I pull it up. Sorry, with the list this morning, I was scrambling.
Yeah, it's an extensive
Yeah,
PC.
I don't know anybody here.
Included several search warrants.
Yes, Your Honor. In this case, despite the Ms. Parasso's low risk score of a 3 and no prior criminal history, we are going to be requesting bail in the amount of $100,000 bondable, pretrial supervision, no contact with the named co-defendant, Mr. Sanchez Paez, and pretrial supervision with testing for drugs and alcohol. Does look like methamphetamine was found in the residence. Given that this is a forgery lab, fraud lab, and given the significant amount of money involved, while only under 10,000, Your Honor, we do believe that a higher bail is appropriate given the facts of this case. So outside of that, Your Honor, we do believe that the use of different IDs throughout, including potential ability to make forged IDs, gives rise to the potential that Ms. Parasso may pose a risk of flight and non-appearance. Again, she does have that low risk score of a 3 and no prior criminal history, but the facts of this case are significant. So we do believe that the higher bail is appropriate in this case.
All right, do we have a response?
Yes. At this time, we're seeking an OR release for Ms. Parasso with appropriate release conditions. I think a no contact order with the co-defendant is appropriate, along with check-ins with pretrial services. The state is correct in terms of the MPRA score. It's a 3, it's a low, no prior misdemeanors, no prior felonies, no prior violence, no FTAs, no multiple substance use arrests, and a verified phone. By all metrics that this court, well, not all metrics, but by the metric in which this court has laid its decisions time and time again, predicated its choices off of, this MPRA score indicates that she is not a flight risk nor a threat to the community, albeit she is faced with these allegations, serious allegations, but all the same. In light of her criminal history, it tends to lean that Ms. Parasso perhaps is not as involved as other individuals in the forgery lab charge, in generating these types of criminal behaviors. I think that's, again, just predicated on what we know and what we know with our MPRA science, which is prior instances of conduct reflect prediction, predictability of future incidents of conduct. Outside of that, she's reported to us that she has worked for the past year, has a local residence that she could return to if afforded that opportunity, lives locally for the past 20 years, so she has deep connections to our community, and that she has a regular phone number to be contacted at. The issue is that we just don't have phone numbers to verify what she has provided us. So in terms of that job and that address, with that information not known at this time, we still have to proceed with the bail determination. I think given her MPRA score, given her lack of criminal history, and given her ties to our community, she is not a risk to the community, nor is she a flight risk. I think an OR release is appropriate, and you can deter future criminality with pretrial release conditions that I've already suggested.
Right. So on this case, is the state requesting a no 10% cash option?
As it is a category B felony fraud lab, I would be requesting a no 10% cash option.
All right. Just bear with me here. Was her address verified? Because it looks like only her phone number was verified in the court services notes.
I wasn't able to verify it because Ms. Parasso was not afforded an opportunity to collect phone numbers before being booked in.
Lived at the same place for 4 years.
Gotcha. Sure.
You want to find out from your client if she still lives at that address?
She is reporting to me that she still lives there.
All right, given a risk assessment and other information that I reviewed, I am going to set her bail, but only at 50,000. It will be subject to a no 10% cash option, no contact with RC Willie, Allied Loan Services, and the co-defendant Jesus Sanchez Paez. She'll also be subject to residential confinement, subject to testing, must live at 500 Arrow Creek, number 2531, and should be subject to pretrial services. All right. Next is Havan Perkins.
Spoke with Mr. Perkins today. We were asked to waive his appearance.
All right, they ready to proceed?
Yes, Your Honor, one moment.
This again is related to the Best Western.
Yes, Your Honor. In this case, the state is going to seek bail in the amount of $5 million bondable, pretrial supervision, testing for drugs and alcohol, no contact with any of the named co-defendants, no firearms, weapons, house arrest with GPS monitoring if he does post. Mr. Perkins scores a 9 on the risk assessment. His criminal history is all out of the state of California. In 2024, he had a felony conviction for felon or addict in possession of a firearm, another felony conviction for the same in 2022, and an underlying 2016 felony conviction for robbery. So given that, Your Honor, the high extreme amount of narcotics located in this case, 1,700 grams of methamphetamine plus, 7 firearms, two without serial numbers, 1 fully automatic and 1 stolen, as well as over 125 grams of fentanyl and $12,000 in currency. We believe he does possess significant assets and it presents an extreme risk to the community, not only through narcotic sales, but also through the firearms he possessed and the conduct that we saw in this case.
The state requesting a no 10% cash option.
Yes, Your Honor, very much so. This is a category A trafficking as well.
Correct. I'm sorry, I didn't hear you mention that, so I just wanted to confirm it.
My apologies, Your Honor.
Are we ready to proceed?
Yes. So at this time, we're seeking a lesser amount in bail. I guess the bail amount ultimately that we hope to land on is something that reflects his score on the MPRA and the identity of the substance that is being allegedly trafficked. So with that MPRA score, it's a 9. Technically, it's a high, but it's a low high. It's far different from anything in the double digits, that's for sure. And in that 9, he had no points for prior failures to appear, and he had a verified phone. I think that's at least worth something when calculating his bail amount. Now, turning to the identity of the substance, the bulk of that substance that he's allegedly trafficking is methamphetamine. I think the state's requested bail amount is more so appropriate for something that has greater lethality in our community, right? If it was north of 1,700 gross gram weight of fentanyl, then by all means, I think $5 million would be appropriate. Now, with it being methamphetamine, not nearly as lethal as something like fentanyl, I think that should also be accounted for in terms of what type of risk Mr. Perkins poses to the community at large. I think with the 9 factored in and with the identity of the drugs factored in, I do think bail in the amount of $250,000 bondable with no 10% cash option is more appropriate.
Just bear with me, I'm just checking some other thing in my notes here. So given the facts of this PC sheet and the several convictions, including a 3rd felony conviction for a felon possession of a firearm, the number of firearms located on premises, as well as the trafficking charge and the gross weight of the drugs found in this case, I am going to set his bail at $5 million, no 10% cash option, no contact with the co-defendants in this case, and Best Western, which is 5851 South Virginia. He'll be subject to residential confinement before release. He'll be subject to testing, shall not possess firearms or weapons, and subject to pretrial services. All right. Next is Mr. Paez, Sanchez Paez.
Speaking with Mr. Sanchez Paez, we would ask to waive his appearance and proceed with the bail hearing.
All right. State ready to proceed?
Yes,
This
Your
is a
Honor.
related case to Ms. Barrasso.
Yes, Your Honor. In this case, the state is going to similarly seek bail in the amount of $150,000 bondable in Mr. Sanchez Paez's case. Unlike the co-defendant in this case, Ms. Barrasso, Mr. Sanchez Paez does have significant criminal history. He scores a 10 on the risk assessment. Looks like he had a felony arrest on a conspiracy to commit uttering from 2023 this year. Felony arrest for false imprisonment, possession of a controlled substance, 3rd offense, and conspiracy to commit uttering. Looks like that case has bail set at $50,000 bondable and is pending before this court. Prior to that, in 2020, he had a felony conviction for possession of a stolen motor vehicle locally. 2019 gross misdemeanor conviction for unlawful taking of a motor vehicle, as well as a misdemeanor disturbing the peace of Carson City. He had a 2018 petty larceny conviction with a failure to appear, 2014 felony conviction for trafficking out of Douglas County, 2011 gross misdemeanor attempted possession of a controlled substance, 2009 misdemeanor domestic battery, 2003 felony conviction for possession of a controlled substance for sale, 2 separate cases, both resulting in convictions. In 2002, he had a felony conviction for conspiracy to commit trafficking, another domestic battery conviction, another domestic battery conviction in 2001. Excuse me, 2 other domestic battery convictions in 2001, as well as another gross misdemeanor unlawful taking. So, Your Honor, given that history, we do believe that Mr. Sanchez-Paez presents an extreme risk of further ongoing criminal activity, risk to the community, and given the facts of this case, presents a risk of flight, as he did have the ability to create false documents. So we do believe that bail to be the least restrictive means. If he is able to post, we'd ask for pretrial supervision, testing for drugs and alcohol, house arrest with GPS monitoring, no contact with the co-defendant or the victim businesses.
All right, do we have a response?
Yes, we're seeking a lesser bail amount. I think the state's original ask for Miss Parasso would be more fitting for Mr. Sanchez-Paez, so 100,000 bondable, no 10% cash option. I think 100,000 is justified in light of his criminal history and the allegations of this charge. I don't think it's justified to bump it to 150,000. I just don't see the nexus in making it so high in terms of that. In speaking with him, he did report having a local address to stay at. He did report having a phone number that he could be contacted with, and that he would be amenable to any supervision conditions. But with that said, we will submit.
All right, well, this was a pretty extensive operation with multiple printers, 216 identification cards, 42 social security cards, 93 credit and debit cards, not to mention all the counterfeit payroll checks. So I am going to set his bail at 150,000. No 10% cash option. I have no contact with Allied Loan Servicing, RC Willie, as well as the co-defendant Jennifer Parasso, subject to residential confinement, subject to testing, subject to pretrial services supervision.
And that'll include testing as well, Your Honor.
Yes, I included testing.
Thank you, Your Honor.
All right. Next is Irene Skenandore. Middle name Michelle, it looks like. All right, is the state ready to proceed?
Yes, Your Honor. In this case, Ms. Skenandore scores a 3 on the risk assessment, but was overridden. The state's main concern in this case, Your Honor, is that Ms. Skenandore was just convicted of driving under the influence out of this court in January of this year, and she does have a suspended sentence on that case. Your Honor, given that, we do believe that some monetary bail in this case is appropriate given the recent conviction and, again, driving under the influence. We'd ask that it be $5,000 bondable. Obviously, no objection to the 10% cash option given the misdemeanor charges, pretrial supervision with testing, and the DUI rant, as well as no driving without proper documentation.
What was the amount?
5,000 bondable with no objection to 10% cash option.
All right, do we have a response?
Yes, at this time, we're seeking an OR release with appropriate release conditions. I think the shortfall with Ms. Skenandore is the lack of sufficient supervision that was implemented as a post-sentence requirement for her last case. I think if we enhance that with this current case on pretrial supervision, we'd likely mitigate any risk to the community she poses. So in terms of pretrial risk or pretrial supervision conditions, I would think a scram device would be appropriate for the time being, just given the closeness in reoffending with this type of charge. And that would be continuous alcohol monitoring for Ms. Genendor. I think that would be a world of difference in terms of reoffending and not reoffending. Again, she scores a 3 on the NPRA. She has a verified job, verified home, verified phone. She has so much in this community tying her to lawful behavior. All the more reason to stay in compliance with pretrial supervision. And I think if afforded that opportunity on a scram device as compared to just regular testing, I think we're going to see a difference in behavior. And I think we're going to be able to see Ms. Genendor be successful on that level of supervision.
Well, I intend to agree with you, although I think some bail amount is appropriate. What I have for condition is $3,000, 10% cash option, residential confinement, subject to testing, DUI rant, no driving without a driver's license or insurance, pretrial services supervision. There was one other one. She must reside at 170 Many Nations Road. All right, those will be the conditions. Again, all she would have to post is $300 based on the 10% cash option. Okay, and the fact that she just had a DUI is a concern as well. All right.
All right.
Next is looks like Precious Sunday.
This is going to work. It's going to be the same thing that's just been happening. Okay.
All right. Is the state ready to proceed on this Sunday?
Yes, Your Honor. In this case, the state is not going to object to the defendant's release. We would ask that the conditions include pretrial supervision with testing for drugs and alcohol, the DUI rant, and comply with PMP. It looks like the defendant is going to be supervised through the Second Judicial District Court. Does have that pending case at diversion. Does look like there has already been a probation violation arrest in that case. Outside of that, the only other criminal history was a failure to appear to arrest in 2024. So, Your Honor, given that history, we do think there are least restrictive means, especially through supervision being conducted with PMP. We would just ask that pretrial be included to also include the testing in this case.
All right, so let me get out of this file. All right, so again, let me just check my notes here. All right, so there will be a release, OR release in this case, subject to testing, subject to DUI rant, must comply with PNP, and it'll be subject to pretrial services supervision. All right. If you're not being held in any other matter, will be released on this case. All right.
I believe there's a PMP hold, Your Honor.
Clerk, would you know the arraignment date?
The same date, March 25th.
All right. Thank you.
All right. Next is This file. Mark Anthony, is it Vaughn?
That's how it is.
Okay. State ready to proceed?
Yes, Your Honor. In this case, the state is going to seek bail in the amount of $15,000 bondable, pretrial supervision, no contact with the victim business address. Mr. Van scores an 11 on the risk assessment, noting 2 points for prior substance abuse related arrests and 2 points for a pending burglary case out of California. In 2025, he was arrested for felony destruction of property with no disposition. He also had misdemeanor assault and battery charges, obstructing and resisting out of Oklahoma that shows no disposition. The criminal history says it was referred to the DA, but nothing further. So unsure if that case is still pending. Also in 2024, he had a felony conviction for assault and battery on a police officer out of Oklahoma. He had a felony conviction for burglary in the second degree, a misdemeanor conviction for indecent exposure, misdemeanor conviction for obstructing and resisting, also out of Oklahoma. 2023, he had misdemeanor convictions for destruction of property and trespassing out of this court. In 2023, he had some arrests for public intoxication out of Utah with no disposition. Then jumping back to 2013, he had a felony conviction for robbery out of California and a felony conviction for taking a vehicle without consent, also out of California, and a misdemeanor conviction for false statement to obstruct out of this court. 1999 felon in possession of controlled substance out of Oklahoma, 1999 felony PCS, and felony conviction for distribution of a controlled substance, and an 89 felony conviction for possession of a controlled substance, all out of Oklahoma. Given that history, Your Honor, we do believe that Mr. Van may be habitual criminal eligible. 1, 2, 3, 4, 5. He is eligible for habitual criminal enhancement, so we do believe bail in this case is appropriate with the noted conditions.
We have a response.
Yes. I think based on my recollection of the PC sheet, I do not recall any indicia of theft from Mr. Van's unlawful entry of that building. So the provability of the charge in itself seems to be shaky at best. Seems more so predicated on Mr. Van having a criminal history in the first place rather than what was actually observed at the scene. I think as a result, this is more so just a trespass case, and if it is to be treated as such, it would be an OR release with check-ins with pretrial supervision. I'm not seeing any other basis to go elsewhere. I understand that he was arrested for burglary of a business, but if there's no indicia of theft or assault or battery or the intent therein, then it's just a glorified trespass. So I do think OR release at this time is more appropriate.
I read the PC a little bit differently. I know he indicated that he knocked and then the door was open. Looks like he was looking for a job. It was unlocked. That's how he arrived at that place. But it goes on to read that looks like the door was kicked open. Nevertheless, I'm going to set his bail at $10,000. No contact with 1725 East Commercial Row. Subject to testing. Shall not possess firearms or weapons. And pretrial services supervision. Okay. Next is Rebecca Bullock.
All right, good to go back. Do I have a court date? No, not yet.
Okay. Looks like this is a fugitive case.
We'll just bet her for 72 then on March 13th.
Okay, so March 13th is her 72,
Yep, for the filing of the criminal complaint.
right? Yeah, I was just gonna read off the, yeah, looks like Minnesota Department of Corrections. All right, so for 72, and what day is that?
March 13th.
March 13th. Okay. After Ms. Bullock is Solomon Jackson. Okay. State ready to proceed?
Yes, Your Honor. If I may just have one quick moment. In this case, Your Honor, the state's going to seek bail in the amount of $15,000 bondable, pretrial supervision, no contact with the named individual in the probable cause sheet. Mr. Jackson does score a 5 on the risk assessment, but it looks like last year he was arrested on charges of sex assault on a child less than 14 years out of this court. The case was no issue due to incomplete investigation, but does appear to still be under investigation. In 2024, he had a no insurance citation where he failed to pay the fine and a bench warrant had to be issued. So limited to no criminal history, Your Honor, but concerning facts given the prior arrest nature and then facts of this case. So we do believe some monetary bail is appropriate. We would ask, given the conduct in this case, that he have no firearms or weapons. And I would just note that one of the main statements that gives the most concern to the state, when he was talking to the victim, he did indicate verbatim, "Fine, I'm not going to sexually assault you," which I think in the alternative gives indication that that was his intent originally.
Understood. All
And
right, do
given
we have a
that, Your Honor, we
response?
would ask, I apologize, Your Honor, given that and the nature of these charges, we would ask for no 10% cash option.
All right, do we have a response?
Yes, so at this time, we're seeking a lesser amount in bail. I believe $4,000 bondable with a 10% cash option is appropriate. Given his score on the MPRA, he doesn't appear to be an actual risk to the community. Instead, it appears that he's merely just been investigated for things that never really came to fruition, likely because they don't hold true proof to them. Going to the rest of that MPRA score, no prior failures to appear, having a verified job, no multiple substance use arrests, and having a verified phone. I think that speaks to his lack of being a flight risk. Again, I think that takes away from the necessity of monetary bail if it's going to be predicated on that basis. Again, we were also able to speak to a reference on his behalf who was able to verify an address. That would make his score from a 5 likely to a 3. That makes him a low risk. On a gross misdemeanor, it's not even a felony. I think that in itself would warrant an OR release with appropriate release conditions. All the same, we are understanding of the nature of the factual allegations and why perhaps that in itself warrants bail. So in the event that this court is not willing to entertain an OR release with appropriate release conditions such as no contact with the alleged victim and no weapons, I do think $4,000 in the alternative would be appropriate with that 10% cash option.
Yeah, the PC sheet does read concerningly. Also some indications that their prior incidences, similar instances, looks like the named victim in this case got on the phone with the police He did admit what he did in the U-Haul. However, I'm gonna set his bail, but based on his risk assessment at 10,000, no 10% cash option, no contact with Cali Bird. I mean, I'm gonna put him on residential confinement, did before release, because he does have a job and he does have a place to live. Shall not possess firearms or weapons. He must reside at 9755 Silver Sky Parkway Apartments. Let's see what his 3204. And it'll be subject to pretrial services supervision. All right, so I think we still, didn't we trail Mr. Stevens?
Yes,
Mr. Stevens would be the last individual, correct?
yes.
Okay. We ready to proceed with Mr. Stevens?
Yes, Your Honor. State is seeking bail in this case in the amount of $2,500 bondable pretrial supervision with testing for controlled substances and no contact with Diamonds Casino. Mr. Stevens scores a 10 on the risk assessment, noting that pending case at the Reno Municipal Court. Already this year, he was convicted of trespassing and resisting out of this court. He had a felony conviction for burglary of a motor vehicle in 2024, a gross misdemeanor conspiracy to commit burglary in 2023. Then in 2022 in Arizona, he had a misdemeanor assault with no disposition, a felony theft conviction out of Arizona in 2017, 16 disorderly conduct conviction, as well as theft out of South Lake Tahoe. The disorderly conduct was out of Arizona. A 2015 misdemeanor conviction for trespassing out of Douglas County, a 2013 domestic battery conviction out of California, 2013 misdemeanor conviction, sex with a minor out of Lake Isabella, California. Unsure why that resulted. I see. And then a 2010 felony conviction for evading a peace officer out of California. So, Your Honor, given that history and the repeated nature of the trespassing and continued conduct, we believe some monetary bail is appropriate, especially given that criminal history.
All right. And did you say no 10% cash option?
I didn't, Your Honor, but that would be my standing request unless otherwise noted.
Okay, that doesn't meet the requirements of the admin order though, does it?
It does not, Your Honor, so I understand what the court's ruling would be.
Okay. All right. Do we have a response?
Yes, at this time, we're seeking an OR release with appropriate release conditions. I think just given the facts and circumstances of the case, a stay away order from that specific place should be sufficient, and just check-ins with pretrial services. While Mr. Stevens does score a 10 on the MPRA, there's no points for prior failures to appear, nor multiple substance use arrests. He also reports that he is self-employed, working as a tattoo artist and a singer. He has a local address he could return to, and he does have a personal phone that he could be reached at for pretrial supervision requirements. Again, we're dealing with a trespass first and foremost. It's a very low-level charge, fairly incidental, and there is no deep, lasting impact to the community as there is with maybe drugs, theft, violence, if you will. As a result, I think an OR release is appropriate with the aforementioned supervision conditions.
Yeah, but he was trespassed according to security 15 times in that one day. He just kept coming back. I'm gonna set his bail at $2,500, but it will be subject to the 10% cash option, no contact with Diamond Casino, 1010 East 6th Street. It'll be subject to testing. Given his criminal history, shall not possess firearms or weapons. Pretrial services supervision. All right, so I think that's it, except we have a few that are coming back tomorrow. All right, is no one else left in the courtroom, just to confirm that again?
There's nobody else. That was it.
All right, I'll see you tomorrow.
Thank
All
you,
right,
Your Honor.
see you,
tomorrow.
Judge.
Take care.